Ready? Exercise number 3, Series C, Legal Matter, start. CRA number 228 of 2020 is an appeal against conviction and sentence. The appellant was held guilty and convicted for offence punishable under section 376 under bracket 3 bracket out of the Indian Penal Code, hereinafter referred to as IPC, and section 6 of the Protection of Children from Sexual Offences Act 2012, for short POCSO Act. He was sentenced to undergo rigorous imprisonment for 20 years and to pay fine of rupees 10,000, and in default to undergo rigorous imprisonment for 1 year for the offence punishable under section 376 subsection 3 of IPC. It was directed that the victim is entitled to get the said fine amount of rupees 10,000 if realized in view of the second proviso to section 357 of the Code of Criminal Procedure, for short CRPC. The department has noted that this appeal is defective as the victim has not been made party in this application or appeal. Stop. Next para. We heard the learned advocates for the appellants in the two appeals, Advocate Saurav Chatterjee, who assisted this court as amicus curiae, Advocate Shiv Shankar Banerjee, assisting from the West Bengal State Legal Services Authority, and the learned additional public prosecutor Mr. Rana Mukherjee. We also had the privilege to hear learned senior advocate Shekhar Basu by way of advisory and assisting intervention. Stop. Next para. We keep aside the provision made in the impugned judgment in CRA 228 of 2020 for payment of compensation under section 357A of CRPC. Since payment of compensation under the Victim Compensation Scheme cannot be subjected to an appeal by the accused, be that person a convict or not, Advocate Saurav Chatterjee referred to the provisions of section 23, 24 subsection 5 and 33 subsection 7 of the POCSO Act to point out that there is an overwhelming legislative trust to ensure protection of the victims. He also referred to the decision of the Honorable Supreme Court of India in Nipun Saxena and others versus Union of India and others, reported as under bracket 2019 bracket out 2 SCC 703. Stop. Next para. Learned senior advocate Mr. Shekhar Basu drew our attention to Article 39 sub-article F amongst the directive principle of state policy. Apart from Article 21 of the Constitution of India, Section 372 of CRPC provides that no appeal shall lie from any judgment or order of a criminal court except as provided by the code or by any other law for the time being in force. The proviso introduced to that section with effect from 31/12/2009 conferring right of appeal on the victim as regards such matters as are stated in that proviso is of no consequence in so far as these appeals are concerned. Section 374 of CRPC provides for the appeals from convictions. Section 385 CRPC prescribes the steps to be taken for the purpose of hearing of appeals which are not dismissed summarily. Stop. Next para. Trial, conviction, and sentence are matters primarily between the accused person and the state. The statutory provisions for institution of the appeal and the hearing thereof do not in their terms enjoy in impediment of the victim in these appeals. The victim is not a necessary party to a criminal appeal from conviction for offences against woman or child, punishable under sections of the IPC or POCSO Act or any other penal provision which will apply in relation to offences affecting human body against any woman and slash or child, both those expressions being understood in the context of the respective legislation which deals with such offences. Stop. Thank you very much.